Thank you.
Okay, good. I think we are only missing Carlos Correa. Otherwise, that starting time is coming. So we will start in a couple of minutes. Thank you very much all. And I can see Uday has also joined. So morning, Uday. Then otherwise, that starting time is coming. So we will start. Okay. There was some echo. I think it is better now. I think we have tested your videos and your mics as well as the PowerPoints by Hardin and Teresa. Everything seems to be working fine. Is it okay if I hope it is okay that we follow the order, which is not any commentary on anybody's status or anything at all? We thought that would make sense to go in that way. Okay, so I will run the webinar in the same order of speaking as is mentioned in the program. Then we have, since our Zoom platform allows only a maximum of 100, so we are going to be live streaming it through the Cuts YouTube channel so that many other people who are interested can join from there. The program will run as per the list. Then we will be requesting the people who are attending, if they have any comments throughout the session, they can post their comments on the chat function. We will be requesting you as and when needed to respond to them. I will be bringing, and my colleague Julia Groli also will be bringing to your attention if there is anything coming on the chat function. And then this year, and in a lighter but still real vein, that I think all of us have become a bit of experts on Zoom platform or virtual platforms. So, but if there is any technical issue, please do immediately send a private chat message to me. I had sent you the WhatsApp numbers of both myself and Julia, who is a technical support senior program officer at CUT International Geneva. So do not hesitate to send him a WhatsApp message as well. Because the other thing that I have learned, despite all this so-called expertise on this technical virtual setting, things do not always work as we hope them to be. But looking forward to a very good conversation this morning. Hey, Carlos, I can see that you have joined us. Thank you very much. If you would kindly unmute yourself so that we can hear if your mic is working.
Hi, Rashid, how are you? Can you hear
good.
me?
Yes, here very well. Carlos, would you have any PowerPoint slides or no? Okay, good. Because otherwise you were just saying that, we have given the control to speakers if they want to share their screens. But good, so we have two speakers, Teresa and Hardin, who would do that. The others, of course, will speak without that, which is perfectly fine. So thank you very much again. So briefly recap, Carlos, what I was saying. I don't know whether you heard that we will start in a very short while, in the next minute, and we will go through the program as per the order given in the agenda, which has, as I was saying, and let me reiterate, has no reflection on any status or hierarchy there. Then there will be questions coming in through the chat function. People will be watching through the YouTube live channel as well. And we will be inviting your attention, speakers' attention to the question as when they come in. And in case of any technical difficulty or otherwise, please send us a message through chat, private chat on this, as well as you can send it to the WhatsApp numbers that I had given in my email of yesterday. So hopefully things will go well without any technical hiccups, but but one should be mentally ready for that. If it is okay, Pardeep, should we start?
Not a bad idea.
Okay. So Julia, would you like to then let the people enter, and then let me just give me a signal, and then I can say a few words to start?
Yes, probably. Well, I think let everybody in already. I see nobody in the waiting room. We are all there.
Okay. Okay, very good. So my name is Rashid Kokap, Executive Director of CUTS International Geneva. A very good morning to all of you. Maybe in some places it is very early morning, at other places it may be afternoon, and in yet other places it may be evening, so good morning, good afternoon, good evening to all of you. On behalf of CUTS International and CUTS Institute on Competition and Regulation to this webinar on World Competition Day 2020. I will say a few words before giving the floor to our Secretary General, Mr. Pardeep S. Mehta, for a formal welcome address. As some of you may know, 40 years ago, on 5th December 1980 to be precise, quite a momentous thing happened, which was that the UN General Assembly adopted what we call the set of multilateral principles and rules for the control of restrictive business practices. In short, the set. This was, as I said, quite a momentous occasion, may not have been noticed so well at that time, but CUTS realized its importance, and through its work, and under the vision and leadership of Pardeep S. Mehta, has been at the forefront of pro-competition and pro-consumer reforms globally. This has been a long journey. A lot of work has been done, and of particular mention, I would say, would be that CUTS International has helped more than 40 developing countries in proceeding further by building, by strengthening, by implementing pro-competition and pro-consumer reforms. Realizing the need and importance of greater visibility, higher level political commitment, and larger stakeholder engagement for this process, Pardeep S. Mehta came up with the idea of adopting 5th December as World Competition Day. By having days celebrated brings a lot more focus on the issue and helps in the reform process. CUTS 10 years ago, it is a decade ago, since 2010, had come up with this call to adopt 5th December as World Competition Day to celebrate this. Since in this last 10 years, through the tireless efforts of Pardeep and CUTS, a number of competition authorities around the world, as well as civil society and several relevant international organizations, have been celebrating World Competition Day on 5th December every year. CUTS International takes the lead by proposing a theme for the WCD every year and organize events on that day. In Geneva also, the CUTS International Geneva, we have been organizing these events every year on 5th December in person. And I'm very grateful that those events were always organized in collaboration with our esteemed colleagues in the WTO and UNCTAD. And both of them are present here with us today as well. The current situation this year, which you all know about, meant that the normal way of working is no more working. So we decided to celebrate WCD through a virtual event and in collaboration with the CUTS Institute on Regulation and Competition. So it is a pleasure to be organizing it jointly with CIRC, and we look forward to a very good webinar today. The theme for this year's WCD is competition policy and access to healthcare, which is quite timely and topical. With these few words, it is my pleasure and honor to invite Pardeep S. Mehta to give his formal welcome address. He does not know any introduction, I know, still let me say a few words. He is Secretary General of CUTS International, President of CUTS International Geneva General Assembly, Secretary and Treasurer of CUTS Institute on Regulation and Competition, among various other things he does. Above all, he is a leader, visionary, scholar, and campaigner who tirelessly has been working on issues related to competition, regulatory reform, consumer protection, trade and development, to name a few. So Pardeep, thank you very much for being here with us today. And now I request you to kindly give us your welcome address.
Thank you very much, Shashi. You have very nicely introduced the topic about what happened 40 years ago in the United Nations General Assembly. But let me add to that, for the benefit of all, that the idea about dealing with restricted business practices was actually mooted first during the Havana Charter discussions in 1948. And the developing countries at that point of time had demanded that there should be a system on which you can control the restrictive business practices of the multinational corporations in particular. That those days transnational cooperation was not in the jargon. And as a consequence of that demand not being met, including the establishment of the International Trade Organization, which came about finally in 1995 in the form of WTO, that the issue was raised in the United Nations that look, this needs certain forward movement so that the developing world is assured about as to how to deal with it. So the idea about the UN, the set, as you called it, I mean, with a very long name, we call it the Set on Competition Policy, was drafted to enable developing countries to draft their own competition laws and to deal with the competition abuses which would take place, whether it is domestically or it is coming internationally. Of course, at that point of time, a large number of world was developing in the sense that they did not have the need to deal with this. And this issue came up again, in fact, in the WTO discussions at the Singapore Ministerial Conference. And that also did not succeed. But let me leave that aside and come back to what happened at the UN. Now, more importantly, UNCTAD has also been supporting the adoption of the World Competition Day by various member countries. And we are happy to say that very large number of developing countries have adopted the World Competition Day. It is not yet a UN day. That is an effort which we continue to make. As much as the World Consumer Rights Day still remains on the anvil, that when is it that the UN system is going to do it? Without getting into the politics of that, the idea was that the movement should move forward in a manner that people become aware. Now, one of the most important achievements of this celebration was Philippines adopting it as their national competition day legally through a presidential proclamation. And so on and so forth, and including, I mean, your country, Rashid, has been celebrating World Competition Day regularly. We have been celebrating World Competition Day in India as well with the participation of our competition authorities. It is not yet recognized as such by the government of India because it has to come from wherever it has to come from. Now, what happened? Let me come back to this issue about this particular theme which you spoke about. It is indeed very topical and extremely, I would say, a big imperative when you look at the 25 years of WTO and 25 years of TRIPS as well. Everything is sort of, coming together. There's a very important convergence. What happened was, year before last, the South African Competition Authority, at that time led by Hardin, organized a session on healthcare, where I spoke, Hardin, Alexi, and others spoke about it as well. And at that time, Hardin and we had a conversation. In fact, it was announced publicly as well, that the next World Competition Day would be observed with the theme of healthcare and competition. We did not know that, we did not anticipate COVID at that time. Or the fact is that we require flexibilities in the intellectual property regime to allow medication and medical equipment to be freely available without any IPR restrictions or any kind of things. Of course, many developing countries, particularly if you remember, even for the AIDS drug, had to, there was an amendment made in the WTO, the TRIPS agreement. In the one of the three declarations in Doha was the declaration on health and TRIPS, where countries, least developed countries without any manufacturing facilities could import AIDS medicines from countries which have the manufacturing facilities. And particularly here, I would say Brazil and India were the two leading countries which were able to supply. Why I'm referring to that is that there is a precedence already on board of looking at flexibilities in the TRIPS agreement to enable people to get access to medicines or healthcare in these terrible times. I mean, I don't think the world has seen a global pandemic like this. I mean, there was Spanish flu, probably killed more people than what COVID has done until now, but it is still restricted to the Western world. It did not get into the developing world. So we do have a very important agenda, and therefore I'm very happy to welcome Carlos Correa, one of our leading advocates on developing countries and TRIPS. Tony, glad to see you here. As usual, the WTO has always been a great supporter of the work we're doing. And this is not to discount in any manner whatsoever Maria, Teresa Maria, with whom we've been working hand in hand and shoulder to shoulder for a long time. With that, let me conclude my opening remarks and to hand over the proceedings to Rashid. Rashid, over to you.
Thank you very much, Pardeep, for bringing that historical, thoughtful perspective. And as you mentioned, all the speakers today have been fellow passengers, fellow travelers on that long road that you had started on. So thank you for that excellent welcome address. Now we will proceed with the presentation of a toolkit that has been prepared on competition and access to healthcare. Before I give the floor for that and introduce the next speaker, let me say that the participants, two things. One, that this session is also being live streamed through CUT's YouTube channel. So that can also be watched from there. Secondly, for your questions and comments, there is a chat function. So kindly feel free to post your questions and comments on the chat, and we'll be looking at that, and at an appropriate time, we'll bring it to the attention of the panelists.
Rashid, if I may just add one important announcement for all, that this session is being recorded, so there will be a WebTube version available to you at a later date also to see and to spread around. Thank you.
Great, Pardeep, that is wonderful. So yes, the recording will also be available later on. To celebrate the World Competition Day today on the theme of competition policy and access to healthcare, we have prepared a toolkit, and this will be presented shortly. This toolkit is also being released formally, and my colleague Julien Grolier will put the link to that in the chat function so that those who are attending can look at that. And of course, it will be released through our various email listservs as well. So to present that toolkit, it is my pleasure to invite Dr. Arvind Mayaram, Chairman, CUT's Institute for Regulation and Competition, who is joining us from Jaipur, India. He is a former Finance Secretary of India and has been chairing the CUT's Institute for Regulation and Competition for several years. His areas of interest and research encompass many things. Among them, competition, regulation are only two. So with this very brief introduction, I request Dr. Mayaram to kindly take the floor, virtual floor, and present the main features of the toolkit. Sorry, ladies and gentlemen, I think we have lost Dr. Arvind. He was there, but now I don't see him in the.
Sorry, I think I got muted for some reason automatically.
Okay, yeah,
so.
yeah. These are the, as I was saying, in this technical world, it's strange sometimes. One does not know what is going on. So glad to have you there, Dr. Mayaram.
All right. Yeah. Thank you, Rashid, and ladies and gentlemen. To keep the market competitive, competition law enforcement alone may not be sufficient. An enabling policy environment that promotes competition in the market, including removal of entry barriers and market distortions, and inducing ease of doing businesses is a critical condition precedent. This toolkit, which we are launching today, aims at building capacities in the use of the ex-ante competition policy and then ex-post competition law enforcement as tools to enhance access to healthcare, built on the belief that access to healthcare is largely dependent on its availability and affordability. This is all the more important and relevant in the wake of COVID-19 pandemic. The toolkit has been prepared keeping in view the developments in the field of healthcare over the years. There are certain trends that are clearly discernible and require policy prescriptions for correction. Some of these are: A, pharmaceutical sector is highly regulated. Market approval and price regulations need to be optimal, that is not more restrictive than necessary. For instance, the regulation of biosimilar generic version of biological drugs has been generally flagged as over-regulated, which creates barriers to generic competition. B, price regulations of drugs where generic competition exists will kill markets' contestability. Price regulation should be therefore used as a last resort in the case of market failure. C, doctors prescribing branded medicines pose hurdle to competition, though they may be doing so on account of, within inverted commas, trust on quality. A nexus with pharma companies cannot be ruled out. Therefore, in order to engender confidence in healthcare system, it would be wise to invest in drug quality regulation. D, a standard treatment guide would contribute to transparency by removing information asymmetries and could reduce cost of healthcare. Hence, better access to affordable and good quality universal healthcare must be the aim of public policy. Generic competition in the pharmaceutical markets is highly dependent on the domestic patent laws. For instance, the change in patent policy of India in the 70s is being credited with the development of vibrant domestic industry and consequent high level of generic competition. The change recognized only process patents, making it easy for reverse engineering of patented products. This led to enhanced access to affordable drugs, not only in India, but in the world. In 2005, when the clause on product patents under the WTO TRIPS agreement came into force, India fully incorporated the same along with its pro-competition provisions, which are the TRIPS flexibilities in its patents laws in order to maintain generic competition. One of the key Indian patent law provision makes patentability criteria stricter to check evergreening of patents. Evergreening adversely affects generic competition. The toolkit also incorporates the issues relating to competition enforcement. With time and exponential advancement in technologies, anti-competitive practices have become complex and sophisticated. Some of these are: A, tying arrangements between hospitals and in-house pharmacies, where doctors are incentivized to prescribe drugs of specific brands available in in-house pharmacies. Similarly, doctors are also encouraged to reject the diagnostic reports from non-affiliated laboratories. B, agreements such as exclusive supply or distribution, resale price maintenance, and refusal to deal creating entry barriers, causing high trade margins and increase in retail prices of the products are also rampant. Excessive and unfair pricing of patented drugs is a major issue. D, pay for delay agreements between patent holders and generic producers to delay generic entry and keep prices of drugs artificial high has been widely noticed. Strategic mergers leading in monopolies or duopolies, reducing competition, resulting in price increase and loss of innovation, or non-compete clauses in mergers and acquisitions, hampering innovation, is also a problem. The toolkit also makes recommendations for strengthening competition enforcement. Some of these are compliance training program for the stakeholders to prevent anti-competitive behavior, in-house pharmacies and diagnostic services as hospitals to be for convenience and emergencies. Any agreement or nexus between the two should be made illegal. Doctors should be encouraged to prescribe generic medicines. Strengthening of competition advocacy to address information asymmetry is necessary. Regular competition assessment of healthcare sector should be encouraged. Compulsory licensing should be resorted to in exceptional circumstances. It is also relevant to understand that extraordinary challenges thrown up by a pandemic of the size and magnitude of COVID requires a strong competition policy response. Some of these are: A, competition policy responses in extraordinary situations are two-pronged, one for smooth supply of essential items like healthcare and food, and the other with respect to the recovery of the shattered economy. Competition agencies in general have allowed collaborations between firms to ensure essential supplies, which hitherto could have been investigated under respective competition and other laws. Some of the competition authorities have laid down certain conditions in which coordinated actions may be acceptable. UNCTAD has also made important recommendations, such as temporarily allowing cooperation arrangements to ensure the supply of affordable products, etc. There has been a strong demand for waiver under the TRIPS agreement. India and South Africa have, in the WTO, called for temporary waiver from the implementation, application, and enforcement of intellectual property protection on copyright, industrial design, patents, and undisclosed information under the TRIPS agreement for prevention, containment, or treatment of COVID-19. The principle behind this demand is that IPR should not create barriers to timely access to affordable medical products or to scaling up R&D, manufacturing, and supply of such products to combat the pandemic. The proposal received support from some countries, civic bodies, and international organizations such as WHO and UNAIDS, while some of the countries are opposing it. The issue is currently being discussed in the WTO TRIPS Council. With this, I commend the toolkit to this August gathering and to the world at large. I'm looking forward to a very productive and meaningful panel discussion. Thank you.
Thank you very much, Dr. Mayaram, for that succinct presentation of the key points in this toolkit, which is quite substantive. My colleague Julia has put in the chat function the full toolkit. There's a link there. So the participants are invited to click on this link and see the various aspects as described by Dr. Mayaram in that version. I will start with the other panel members. As I had mentioned earlier, we have had the pleasure of organizing World Competition Day every year in Geneva in person. with active collaboration of UNCTAD and WTO. And I'm very glad that both the organizations are well represented in the panel today as well. So our first panelist is Maria Teresa Moreira, Head Competition and Consumer Protection Branch, UNCTAD, she has a long, rich experience on consumer protection and competition issues, including as head of the Consumer Protection Agency in Portugal before joining UNCTAD. It has always been a pleasure to collaborate with her, and I'm very grateful that she could join us today from Geneva. So, Teresa, you would have the floor, and as I understand, you are going to share your some slides as well. So please share your screen when you are speaking. The virtual floor is yours, Teresa.
Thank you very much, Rashid. Greetings from Geneva. Good morning, good afternoon, good evening. Allow me to start by, first of all, congratulating CUTS and especially, of course, Pradeep Mehta for again organizing a very interesting discussion to celebrate the World Competition Day. I would like, exactly because of this, just to share with you, I hope you are able to see this now. Just 2 slides to signal exactly following Pradeep's initial words that UNCTAD is proud to be the focal point for competition and also consumer policies within the UN system, that we have been the custodian, so to speak, of the UN set of principles and rules on competition, and that this year we celebrate the 40th anniversary of the UN set, which so far is the only international agreed instrument in this field, and under which, and of course in cooperation with other international organizations, networks, and strong engagement from several civil society partners such as CUTS, have led to the adoption of competition law and policy throughout the world, especially by developing countries and countries with economies in transition, which I think is the most remarkable achievement. And also adding that what we have been witnessing, that regional economic organizations whose members are developing countries have also been recognizing the importance of competition law and policy as a tool to achieve economic growth and inclusive sustainable development. My second slide is just to underline that it's actually under the UN set that UNCTAD, of course, received this mandate formally on competition law and policy, and also that it is the UN set that established the 2 main steps, so to speak, of the international institutional machinery, the UN conferences to review the set that take place every 5 years. And we recently held one in October, well, in an hybrid format, so more virtual than actually physically, where the mandates, both on competition and consumer protection of UNCTAD were reviewed. And we hold annual intergovernmental group of experts meetings on this issue, where we have the pleasure of having discussed actually the topic of healthcare and competition recently, a year ago in 2019, but this has also been the subject of other roundtables and even papers by UNCTAD. I also wanted to take this opportunity to say that in October this year, we were very pleased to have member states adopting a document entitled Guiding Policies and Procedures that in a way gathers a number of practical recommendations to facilitate international cooperation between more experienced competition authorities and less experienced competition authorities, usually from developing countries. And this is a very interesting achievement because it is a set of recommendations, as I said, that are supposed to facilitate this cooperation under the chapeau of the UN set. So in a way, bringing the set to life, and the UNCTAD Secretariat is very grateful for all member states and relevant stakeholders that engaged with us in these discussions. Now, let me please let me try to stop sharing the, not sure that I can, okay. Okay, thank you. Let me now get to the topic with some general remarks. It was very interesting, of course, to hear the presentation of the toolkit, which I think in any case covers with more detail everything that I'm going to mention. Just a couple of points. First, to start with how the outbreak of the pandemic really highlighted that access to healthcare is crucial around the world. I would like to quote some statements from a recent UN policy brief on COVID-19 and universal health coverage, which is from October this year, saying that, of course, that there is greater urgency to the quest of universal health coverage, since health is a fundamental human right and universal health coverage is a critical tool for achieving health for all. This is also to introduce this observation that was already shared by Harvind, that during the pandemic, we saw competition law enforcement by competition authorities and competition policy proving to be extremely effective in stopping anti-competitive practices and abuses of market power through four, I would call, lines of work, with several examples related to the healthcare sector. I won't get into details because I'm sure that, for instance, Hardin will have very concrete examples. But so the first line of work, of course, is enforcement related. So competition authorities were very active against cartels, against abusive tying of practices related to essential goods and other products of what we call now protective personal equipment, so PPE, also to excessive pricing by dominant undertakings and other abusive commercial practices related, of course, to essential goods such as masks, hand sanitizers, and other PPE, as I mentioned. This also led to very strong and vigilant market monitoring by competition authorities, in some cases leading to warnings or recommendations to businesses to encourage compliance when appropriate. The second line of work is also an important one. This refers to exemptions, and UNCTAD did underline how this was extremely important in these exceptional circumstances that all of us have been going through this year. So either to sector-specific block instruments or guidelines to facilitate on a temporary basis horizontal cooperation agreements to ensure the supply of essential goods and services during especially the confinement periods, but also to facilitate and encourage research and development projects directly related to pandemic pharmaceuticals and medical equipment. Merger control has also proved to be a useful instrument, since we have been witnessing the shutdown of businesses and increasing filings for bankruptcy all over the world. This, of course, will be followed by increased market concentration, especially in sectors where access is already so difficult due to the necessary, very important investments such as the healthcare sector. So I think this is an extremely useful instrument for competition authorities when possible, not only to conduct a very careful prospective market analysis, but also to consider imposing the necessary conditions to promote fair competition and consumer welfare and really contribute to level playing field. And the final line of work, of course, is advocacy, because I think that the economic recovery packages that were launched by governments across the world with significant amounts of public funds provided a unique opportunity for competition authorities to advocate a pro-competitive approach translated into specific commitments or conditions imposed to targeted companies or specific economic sectors, and also for competition authorities to really expand their role in the assessment of new or revised legislative and regulatory frameworks. So, well, competition law and policy has over time had a key intervention in addressing market inefficiencies and rising prices in healthcare markets. Of course, the pricing of pharmaceuticals is complex, varies from country to country, and since governments are usually large customers of pharmaceuticals, medical device, and healthcare services, this also has a very huge impact in public budgets. As we know, sectoral regulation, especially in what concerns pricing regulation, may be more applicable and more appropriate in relation to pharmaceuticals. And the other important aspect is, of course, intellectual property rights that play a significant role in promoting innovation and research and development. And here we usually all know that a balance needs to be struck between encouraging innovation and allowing it to benefit all. IPR owners may restrict competition through the abuse of IP rights, through not only excessive pricing or the refusal to grant access to essential patents. And of course, this runs the risk of leading to over-intervention by competition authorities, reducing incentives for firms to invest and attract new entrants in the markets. Well, the World Trade Organization and concretely the TRIPS agreement afford flexibilities, including the adoption of compulsory licensing. But so far, we have not really observed member states taking, I would say, considerable advantage of these flexibilities, even though there are shared concerns regarding access and affordability of healthcare. Of course, UNCTAD having a mandate devoted to the better integration of developing countries in the world economy, has often encouraged developing countries to benefit from these flexibilities. And in the context of COVID-19, I think there have been a lot of calls to pharmaceutical companies and governments to make, especially the COVID-19 vaccines, accessible and affordable, even though, of course, the healthcare sector raises other issues, not only now related to the pandemic. So I would like to come to an end saying that because universal health coverage is at the center of the UN Sustainable Development 2030 agenda, because this is a key priority for policymakers, sectoral regulators, and of course, competition authorities all over the world, it is extremely important, even though public interest considerations may currently override other goals and exceptionally justify options that are not fully competition friendly, that competition authorities remain involved in the design of regulatory interventions and continue to enforce competition law against cartels and abusive practices in this sector. And I would like to underline that also from a consumer protection point of view, the United Nations guidelines for consumer protection emphasize the importance of informing consumers about products and services, and this can be very relevant regarding the COVID-19 vaccines, and also to improve information asymmetries. So from a competition and consumer protection point of view, improving access, improving information, improving the quality of services, and ensuring that consumers are able to benefit also from e-health services, which is actually a project UNCTAD is working with other UN regional economic commissions within the context of the response to the COVID-19 crisis. Thank you very much.
Thank you very much, Teresa. Several important points, and I would not try to summarize them, but this point of what under the current circumstances, which are very unusual, and you mentioned 4 levels of action by the competition authorities, including enforcement and monitoring, exemptions, merger control with necessary conditions, and advocacy. while trying to ensure that the SDG goal of universal healthcare by 2030 is also kept in sight. Very interestingly, of course, and very relevant, that you also mentioned the issues of price regulations in healthcare and intellectual property rights, something that was mentioned by Dr. Arvind as well in his presentation. I'm sure other panelists will be coming to those very interesting aspects as well. So we move on to our next speaker, a player to now move to South Africa, Mr. Hardin Ratchisusu, Deputy Commissioner, South African Competition Commission. As Pradeep mentioned in his welcome remarks, it was Hardin and Pradeep on a panel in the Intergovernmental Group of Experts on Competition Policy and Law last year in UNCTAD, where the idea emerged to celebrate the WCD 2020 on healthcare and competition policy issues. He has been in the South Africa Competition Commission, has been a very valuable partner, a steadfast partner to CUTS International. It's a pleasure to have him with us today. So Hardin, now you have the floor, and I understand that you will also be sharing your screen to show some slides. You will have about 8-10 minutes, so please go ahead.
Thank you very much, Rashid. It's indeed a pleasure to participate in this webinar celebrating the Competition Day, and of course to your Secretary General, Pradeep Mehta, and he has kindly and given us much credit in coming up with the theme this year. But as you know, CUTS International has been working tirelessly in this sector for many years, and it is a culmination of these efforts that bring us here today. We thank UNCTAD, and leadership of Teresa. We were able to debate and discuss issues of health care in 2019 at the IGE, and I'm hoping that that discussion would not just end there. It seems to me that there are still challenges in this area, and there are complexities that countries have to grapple with, and I think there's a need to be flexible and adaptable to the challenges we face in the world today. I will share my screen presentation to take you through our experience from South Africa on these issues. Of course, I will today I will have a disclaimer because of this. There are a lot of things going on, so I have to be clear that this does not in any way reflect the views of the government of South Africa, and also not necessarily the views of the Competition Commission, but where we have made public statements. I think they are there for public record. We will cover a few things, but there's a case that I want to focus on today. Our intervention in the ARVs market in South Africa, just so to signal what is it that can be achieved if we address some of these pricing challenges. And of course, Teresa has painted the picture, the challenges we face. There are still challenges of high prices of some health products and inequitable access to such products within and among countries, especially those that face hardship. And we know there are Sustainable Development Goals 2030 that we have to meet. COVID-19 has put a spanner in the works. It has disrupted economies, and it is now a global pandemic that we had never faced before, as Pradeep mentioned in his opening remarks. The issues that we know, and these are common cause, we have said there are excessive pricing concerns in pharmaceuticals, and there are cases to illustrate these points. it is interesting that many jurisdictions around the world are beginning to look into this. And we have had cases in the UK, the EU, where these issues have been looked at. Pay for delay, most of these cases were found in US, EU, where these issues of IP abuses have been addressed. There are funding and facilities, and this is something that we are introducing to the topic because we have assessed the market through our health inquiry in South Africa. And it's important that, at least in South Africa, most of the care, and we do have a very strong private sector in this space. So we have been looking at the cost of private healthcare, which has been escalating for many years. I've already mentioned the cases that have been looked at in the UK, EU, India, very active. South Africa, we are looking at this case, which is quite prominent, against Roche, for excessive pricing of this breast cancer drug. We are experiencing some challenges of obtaining information from Switzerland, but we will work tirelessly to get to the bottom of this case. I think I should mention just funding and facilities. We found that where there is some competition in this space, we have to look carefully, and many countries have done this, and we have to understand that there are these information asymmetries between the patients and the providers, and with that comes some failures in market. There is unequal bargaining power. We have been looking closely into measures. There are a lot of creeping measures we find in the healthcare space that we need to pay attention to. We have this case in South Africa, and this is a case we resolved in 2003. But this case is crucial and critical because it marked a new trajectory for South Africa and access to healthcare, particularly for ARVs. Individuals infected with HIV, healthcare professionals, trade unions, and NGOs raised complaints against GSK and Boehringer Ingelheim. They alleged that these companies were charging excessive prices in contravention of the Competition Act. The Competition Commission looked into this case, and interestingly, it reached a settlement with these companies. That was early in 2003, and they agreed to grant licenses to generic manufacturers, to permit licensees to export relevant ARV medicines, and also issues of licensing were addressed in that remedy. What did we see, especially with the introduction and permission for these generics to enter early in the space? We saw prices dropping significantly. I show in the chart here, these are the drugs that were being offered in South Africa. And eventually, this ensured, and as you know, South Africa was able to provide access to the majority at now more affordable rates. And when we track prices of ARVs, I think South Africa fared very well amongst a number of countries. COVID-19 has disrupted the markets. We have embarked on enforcement actions to contain price surges. There are shocks that we are aware of, but now we have to carefully look at these pricing issues, because as you know, with vaccines now in high demand, having been to be supplied across the world, we are going to have serious pricing challenges if we do not pay attention to this. We know that there could be measures that could be entered into firms under distress and so forth, but this is something that an area as competition authorities we should continue to pay attention to. Policy developments in South Africa, this is very important because in 2018, and I think this is Teresa is challenging. Many countries have not taken advantage of these flexibilities that are there. In 2018, South Africa adopted an intellectual property policy with initial focus on public health and with other areas to be determined in subsequent phases. And in that policy, it quotes the Doha Declaration. And I won't repeat this because I think the people a lot in this audience are familiar with this. But the key thing here is that there is a need to take advantage of this flexibility, but it's even more crucial in healthcare. The policy in South Africa, the new policy, the policy that has been adopted, is looking at issues of patents, parallel importation, compulsory licensing, and all the other reforms that are needed to ensure that we see entry of these generics in the market. We think, and when I observe these reforms, such as those being adopted in South Africa, are necessary to ensure inclusive healthcare for all. And COVID-19 has shown that if we do not obtain pharmaceutical products at more competitive and affordable prices, there is going to be a global health catastrophe. There's going to be limited access to these vaccines. COVID-19 pandemic has shown that if the cost of the required pandemic is not kept in check, we are going to have challenges as the world. And recent steps, and I think when we introduced the toolkit, there are recent steps by India and South Africa at the WTO calling for the suspension of some of the protections for IP related to COVID-19 products. And these measures are necessary to ensure equitable access to healthcare and acceptable pricing practices for these pharmaceuticals. But these have to be looked at probably as broader reforms that countries have to grapple with as we move forward. In conclusion, and I've drawn this from the discussion on competition in healthcare markets at the UNCTAD, where it is quite clear that although competition policy, and we agree that it will not be able to resolve all the challenges, it is quite important that we apply competition law in this sphere, particularly in this contested area, whether should competition authorities intervene on IP protected products. Our view is indeed where there is exploitation, there is a case for intervention, and the cases in the UK, South Africa, India, Europe have shown this. We should pursue indeed and advocate for enabling policies to ensure governments increased expenditure in healthcare services and prioritize those issues in pharmaceuticals and healthcare markets. There's a need, of course, for cooperation among competition regulators, and competition policy, as we argue, will remain an important tool, and the recognition that measures that seek to stimulate competition, measures that seek to restrict exploitative pricing are needed to ensure that access to healthcare is affordable by all. And thank you very much for the opportunity to share our perspective, and we do look forward to further engagements, and I'm hoping that in the not too distant future we will reopen these discussions at the UNCTAD level. Thank you very much.
Thank you very much, Hardin. Thank you for several important points. If I could pick three of them, the issue of pricing, based as you gave the examples globally, as well as the very interesting South African example. So definitely a critical issue. Very relevant to talk about COVID-19 impacts and distinguishing between the immediate short-term versus the more medium-term impacts, and the need for competition authorities to be aware of that and play their effective role. And finally, the intellectual property, from the famous TRIPS and Public Health Declaration at the time of Doha in 2001 to the present proposals. I'm sure that on these points, other speakers will also comment, and probably it's a nice coincidence that the next speaker in our list, Dr. Carlos Correa, the Executive Director of South Center, was quite a force behind that TRIPS and Public Health Declaration in 2001. We had the pleasure of working together at that time also when I was working in the South Center. So Dr. Carlos Correa is going to be our next panelist. He is Executive Director, South Center. His experience spans innovation, competition policy, intellectual property, as well as healthcare. So he comes with a rich experience and knowledge on all these issues. So Dr. Correa, pleasure to have you here, and the floor is yours.
Well, thank you very much, Rashid. Thank you, Pradeep, also for this invitation. I'm very pleased to meet you virtually and to celebrate this World Day of Competition. I would like to make a reference to, in the first place, to the freedom that countries have in order to design their competition policies. As you know, there was an attempt by the European Union to introduce competition policy in the WTO. That was done at the first conference of the WTO. So there was an attempt to introduce disciplines in the context of already these heavy agreements. But many countries, not only developing countries, but also the United States, opposed to this. In fact, the United States didn't want to lose the flexibility and the freedom to develop and apply their policies on competition as they like. Then importantly, in the area of competition, unlike the case of intellectual property, governments have a lot of flexibility in order to define, firstly, what the objectives of the competition laws and policies are. Is it just to protect the competitors? Is it also to protect the consumers? Is it development? For instance, if you look at the South African law, there is the concept of development. Is it social and economic welfare? It is getting access to affordable medicine. So importantly, there is a lot of room for countries to set the objectives of their competition laws and policies. The same applies to the type of doctrines which are used in order to enforce competition policies. If we look, for instance, at the history of the United States, as we know, a very rich history in competition law, the doctrines applied have changed over time. So there was an antitrust concept, very active by a lot of activism by the antitrust authorities in the 70s and 80s. Was 60s and 70s, more precisely. Then there was the influence of the Chicago School of thinking about competition. And then the concept of efficiency became, economic concept of efficiency became prominent in the analysis of competition issues. Then there was the so-called post-Chicago competition school, so on and so forth. So this is just an example showing that also in the way in which a competition law is enforced, there may be changes and differences. And what I'm arguing for is for developing countries to design their competition laws in accordance to their national interests, including in the area of public health, of course, not only this area, but including public health, and also to devise the doctrines, the principles under which these laws are applied in order to achieve their national objectives. So in this context of room for policy space, I would like to refer to a few issues because we haven't got too much time. The first one is something very, very simple, and this is the definition of the regular market, which is a crucial concept in order to undertake an action under competition law. There is no universal definition, as we know, and in the case of pharmaceuticals, there may be some issues that will need particular attention. It was mentioned there are many complexities. Just to give you an example, in the case of insulin, insulin is known for almost 100 years. Curiously, there are still patents on insulin. And insulin, despite it is a very well-known product, prices of insulin have increased over the last decades significantly, both in developed and in developing countries. There is a huge concentration in the market of insulin. Then in insulin, you have two types of products. You have what is called the regular insulin, the regular human insulin, and you have the genomic version of insulin, which is called analog insulin. So one question is, are these products substitutable? So what kind of doctrine would be applied in relation to the supply side substitution? Will we consider the market, including both of them, or just each of them in order to look at concentration and possibly abuse of dominant position? So what I mean is that definition of the relevant market is something which is, of course, fully left to the national authorities. And in the context of the pharmaceuticals, there may be a need to look at this in a very precise manner, and of course, some reviews and investigation will be necessary in order to apply the right concept. A second issue is exercise versus acquisition of intellectual property rights. Under the jurisprudence of the European Court of Justice, which is quite influential over the world, including developing countries, it is argued that competition law can apply in relation to the exercise of intellectual property rights, for instance, patents, and not the acquisition as such. In my view, this is not necessarily a policy that should be followed. In some cases, the acquisition of patents, for instance, the constitution of patent thickets, evergreen strategies, that mean that a large number of patents are obtained around a particular active ingredient or molecule. These practices should also be subject to competition scrutiny. Just to give you one example, the case of ritonavir, antiretroviral, the World Intellectual Property Organization found 800 patents around this single molecule. So my suggestion is for the authorities not to follow this approach, the European approach, but to consider that both the exercise and the acquisition of patents and other intellectual property rights may be subject to action by the competition authorities. A third issue has been already mentioned is excessive prices. Excessive prices are not dealt with in the same way in different jurisdictions. Again, here there is no model that needs to be followed by developing countries. Interesting, in the case of South Africa, there have been some precedents in this regard. Also, in the European context, there was this United Brands versus Commission decision at the end of the 70s. So there are precedents. And there is a lot of room for competition authorities to act when there is excessive pricing. For in the case of European precedent, there was a distinction between excessive pricing and fair pricing. This is one approach, this is one theory. But to the extent that competition law is aimed at protecting not only competitors, but consumers, I would say that the control of excessive pricing, not just through regulatory prices policies, but through competition law, must be one of the actions that need to be taken within the scope of the authorities. A fourth issue is the so-called essential facilities doctrine, which was invoked in an early case in South Africa regarding access to antiretrovirals. It was actually applied, interestingly, in one case by the Italian competition authority, in one case relating to access to an antibiotic by a generic company. This antibiotic was under patent. Again, on essential facility doctrine, there is no single approach at the international level. So there is a lot of room and flexibility for governments in developing countries to apply this doctrine as they consider it is suitable. And in my view, it's a very important one in the context of medicines or vaccines. When there is no substitute for a particular product, this may lead to excessive pricing, of course, and then the essential facility doctrine may be one way of dealing with this issue. Just to give you an example of excessive pricing, a few months ago, there was a product approved in the United States by the FDA, and the cost of one dose of this product is $2.1 million US. So there are so many examples. The case of sofosbuvir, in which in countries where there is a patent, the cost of one pill is about $1,000, when the cost of manufacture, in accordance to a report made by the UN agency, is between $1 and $2. So I think that the use of the essential facility doctrine is one of the tools that competition authorities can employ. There are others, for instance, refusal to deal, what was mentioned, is also very important. So there are many other issues that could be considered within this framework of flexibility and room for maneuver, policy space that governments have. What I'm arguing for is for competition authorities in developing countries to consider issues relating to pharmaceutical sector in a more systemic way, in a more regular way. Since there are many complexities, it may be interesting, for instance, to consider developing guidelines on this particular issue. So this could be an important development in order to help competition authorities to look at this very particular market where concentration exists in many areas, with these practices using intellectual property in order to limit generic competitions are so common. And then let me finish making some propaganda. A couple of days ago, the South Centric has published a document, the research paper 125 by one of our colleagues, Vitor Ido. And this paper examines the use of competition law in order to deal with anti-competitive practice in the area of pharmaceuticals. So this can also provide some information. But thank you very much, Rashid and Pradeep, for your kind invitation.
Thank you very much, Dr. Correa. Thank you for a number of important points. And the key point you were making is that when it comes to competition policy and law, there is a lot of flexibility which developing countries particularly should look into and try to make use of that, because there is no one size fits all. And you gave a number of examples from around the world. And so their developing countries, competition authorities should be conscious of that opportunity, that policy space, that flexibility in whatever way we describe that, and use it while defining the relevant market, exercise versus acquisition of intellectual property rights, and so on. Then it was also very interesting that you brought in several respects the issue of excessive pricing in the healthcare, which seems to be a recurring theme throughout this session, and not surprisingly so. And very, very interestingly, and I think very constructive manner, you have alluded to the need of developing guidelines, which I'm sure would be a suggestion that would be taken up by colleagues. So thank you very much. Now we move to the next speaker on our list, Mr. Alexei Ivanov, the Director of BRICS Competition Law and Policy Center in Moscow. So from Geneva, we move to Moscow now, where I imagine the weather would be even colder. So Alexei, pleasure to have you here with us today. And you have about 8-10 minutes to make your intervention.
Thank you, Rashid, and thanks everyone for having me for this, I think, extremely timely and important discussion. And Moscow is really, like you're right, it's cold. It's winter is coming here. So winter is coming actually to the world with a certain, pressure of this COVID pandemic and all the economic consequences of this global health crisis. So I think we are really in a position to rethinking the way we approach this type of global crises, and our attitude, our tools, which we use to fight possible, market flows in healthcare sector, I think are of vital importance for this. In my short intervention, I would love also to share some slides with you, if you don't mind, because I want to cover a topic related to merger review in the pharmaceutical sector. And I think it was a type of toolkit you provided initially, cards provided initially for our discussion is extremely important, because we need to structure and think a little bit, first structure and then think a little bit out of the box. What are the appropriate competition law and policy tools for fighting this health crisis? And I want,
please, Alexei, go ahead. You can share your screen with these slides. You should have the control to do that.
I'm doing this. Here we are. Sure. Can you see them?
Yes.
Great. In the pharma sector, and now I quickly move directly to the point. In the pharma sector, we a little bit used to the understanding that big pharma, those companies, those are basically producers of the drugs we all need for fighting major diseases. But currently, we're actually having a kind of stagnation in production of new drugs. And this stagnation is actually even decline in production of medicine necessary for treating major diseases and fighting these healthcare crises is quite obvious. And it's noticeable by the dynamic, how many new drugs actually registered, how many new actually breakthrough solutions are coming from the industry. And we see that industry is more like focusing on preserving the status quo rather than coming with breakthroughs. And actually the COVID pandemic, I think it's pretty characteristic of this problem, because what we see is that healthcare system all around the world was not prepared for fighting this global crisis. We still in discovery of proper treatment for COVID. We in discovery of proper, vaccine didn't happen. So we're not prepared. And basically, I mean, it's easy to say that it's pharmaceutical industry or science failed with this, but actually, I think also authorities and the institutional structure we're having for encouraging innovation in the sector also partly to blame. And for quite a while, most of the authorities, competition authorities, other regulatory bodies in the world, they were kind of considering big pharma as a, sacred cow or somebody we can't touch in a sense because they producing innovation. But what we see currently is actually majority of innovation coming mainly for smaller startups, research groups, and then being acquired by the big pharma, they becoming products. So big pharma is much less active in R&D, in the research part of the story, and much more like focusing on marketing part of the story, becoming more like tools for marketing and promotion of the discoveries which happened somewhere else, in public institutions or within startup community. And we see actually that what drives now profits of the big pharma is mainly investment in marketing, in advertising, in regulation and lobbying is extremely well paid investment. And they earning on financial markets where they getting, through some sort of hypes and encourage investors to bring more money to these big pharma guys. And as an outcome, we see the dynamic in the industry where big pharma acquiring more and more and more startups, products, and putting them into the marketing machines, and to a certain extent stockpiling them and keep them on their shelves, basically sitting idle with those innovations because they wait until their existing blockbusters, existing, distributed or well sold products would be living from patent protection. So this is one of the problems actually competition authorities have to focus, in a sense that really changing the perception of how to regulate this concentration happening in the pharmaceutical markets. And you rightly mentioned in the toolkit that actually authorities have to rethink the type of analysis used in merger review. And I think it's also important to rethink the way intellectual property protection, data protection, all the instruments we relying in supporting and stimulating innovation, what role do they actually play in the context of developing of the healthcare products in the global context? And that's kind of extremely important focus that competition authorities have to keep in mind and have to think about. So what I'm actually saying in terms of changing the approach, the current approach in the analysis of mergers, what we see that actually authorities do not think much about the industry itself, about the research landscape in which this company is operating. They don't really see about influence the particular merger and particular concentration would have on a broader landscape of innovation and development. And this is focus shifting, from analysis of particular transaction into putting this transaction in a context. I think it's extremely important that competition authorities start to use more actively, and we see some attempts in this field. We see some new approaches already taken by European Commission, by some of the BRICS authorities as well, in developing countries as well. We see it, but it's still kind of getting momentum. It's still very slow, and here we are to change presumptions. Here we are actually facing this challenge to change presumptions, what Carlos was mentioning, that to change kind of meta script, to change the perception of how markets operate and what is the role of competition authorities in this context. So I think it's very important that you bringing this discussion to the forums like UNCTAD or other international fora where you can change this meta script in perception how the healthcare market operates and what could be a new role of competition authority in this context. I would say that turning back to Moscow, Russia is really lagging behind in this process, and it's a little bit of shame that we didn't support this initiative, which you mentioned, India and South Africa brought to WTO with intellectual property waivers for a certain period of time. But also, I think it's very important that BRICS community and developing countries they can bring, some more new ideas to different fora like UNCTAD and WTO, where they can say, look, we have to change the script. Otherwise, we're stuck with the current healthcare crisis, and we can't really change much. There are a number of actually empirical studies are now published, which analyzed the period of last 10 or 20 years of mergers in pharmaceutical sector, and most of the studies they kind of conclusive in saying that look, in most of these cases these mergers suppressed intensity of innovation, R&D dynamics. They didn't really allow to bring more new products to the market. We see a lot of this phenomena of killer acquisition happening, and when small startups basically killed by acquisition by major corporations. So I think this type of problematic, if we bring it to the global discussion, is of extreme importance. I just, if I have a couple of minutes, Rashid, or shall I wrap up?
Please wrap up. We have one more speaker to go. Thank you, Alexei. One very, very interesting points, and yeah, maybe there will be time in the questions as well. So yeah, kindly if you can conclude by taking a minute or so more.
Yeah, okay. I would just say that, look, when we promote this type of new toolkits and guidelines for global community, and I think it's very important that authorities engage in meaningful discussion on change of presumptions, because we do need to change the meta script, the perception which was developed through, I don't know, through last 20 years. And as Carlos was rightly mentioned, that it was a product of Chicago School, intervention, some sort of neoliberal perception of how marketplace works. So we do need this change, and we do need to not only fine tune, but really like dramatically change, systematically change the work of competition authorities in the healthcare sector. Thank you, Rashid, and thank you for the opportunity to be with you this morning. Thank you.
Thank you very much, Alexei. Excellent points, and you took this approach. And I mean, of course, your main point, this need for change in meta perception which makes a lot of sense. And then you look at the evolving situation in terms of the innovation and R&D. So what is happening in that area? So very interesting to see that, so to say, the players there, their composition is changing. So, and where are the profits being made by big pharma? Not on R&D, but more on through lobbying and marketing and capital based. And in that sense, what should be the role of competition authorities, and particularly when it comes to mergers and acquisitions? Because if I oversimplify your excellent presentation, the innovation is taking place by smaller players, but the fruits are likely to be reaped somewhere else. Is this good for a global innovation system, or what should be done about that? So thank you very much for your presentation. Now we move to the last speaker in our list. I'm very grateful that Anthony Topman, Director, Intellectual Property, Government Procurement, and Competition Division at the WTO is with us today. As I had mentioned at the beginning, that each year we had organized WCD events in collaboration and jointly with the WTO Secretariat and UNCTAD. So very good to have him here. And he will be our last speaker, but certainly not the least important. Anthony had a rich working experience on intellectual property issues in academic area, as an Australian diplomat, and as a director in World Intellectual Property Organization before joining the WTO. So, Tony, you have the Zoom floor.
Thank you very much indeed, Rashid. And I'd like to start by acknowledging the extremely valuable work of CUPS. We were delighted last year to be able to actually host this annual event, and my presence today really represents our respect for the work you're doing and the great priority we give to cooperating with you. And so I'd like to thank Pradeep and you yourself, Rashid. I'd also like to thank you for your guidance in terms of timing, because I know we're against the clock. I have some prepared remarks, but I might cut them short very briefly. So if it's a bit hectic, please forgive me. I also wanted to...
Tony, yeah, please, I want to be fair to all the panelists, so would not punish you being the last. So yeah, you have about 8-10 minutes like everyone else.
Okay, thank you very much. Well, in any event, I'm humbled by the preceding panelists. It's a really stellar group of people, and I acknowledge their really excellent presentations. Accordingly, I will play a more humble role. I will have to introduce the usual bureaucratic caveats that I too am not presenting a view on the behalf of the WTO or the Secretariat. As you can see from the screen, I'm both virtually and actually outside the WTO walls, and so I'm offering what is a personal response. Nonetheless, at this time, we are extremely conscious of the need for global solidarity, for cooperation, for open dialogue and mutual support, and certainly acknowledge the incredibly valuable role of CUPS at this critical time, the challenges we're all facing. I think one of the important points that's come out very clearly already, I think from really all presentations, is the important role of competition agencies and their advocacy function. Even when we look at the technicalities of the IP system, there is concern naturally that these are used effectively in a pro-competitive manner, and even within the existing legal policy framework, the advocacy role of competition agencies, as it's been highlighted even by Alexi recently, is a very important element in ensuring that there is an enabling policy environment. From that point of view, if I can offer a comment as a peer, as a professional rather than as an official, I think the toolkit is a very good summary of the current issues and a very helpful contribution to raising awareness of the role of competition authorities and the issues to be raised. It takes its place alongside other very valuable materials. Teresa's team, the work of UNCTAD, the UN set, these all fit together. I'd like to address the issues initially very broadly, and then I hope, if I have time, very specifically. We do know that IP systems and the TRIPS agreement are designed to take account of the balance of IP rights with broader public policy interests, that rights are not absolute. even the very technical patentability criteria have to be understood as, if they're effectively applied as part of a broader competition framework, and hence the importance for active challenge procedures, opposition procedures, and so on, to ensure that patentability criteria are accurately applied. That's, if you like, the start of the story in terms of ensuring a balance between the IP system and competition interests. Likewise, and of course, currently today we hear a very active and rightly so a discussion about TRIPS flexibilities. I cannot, because of my position, comment on the current debate between our members on the waiver matter, but of course I acknowledge that that's an extremely significant and timely discussion. But even to go back to the Doha Declaration, which has been touched on already, it's important to recall that in the situation of previous epidemics, in paragraph 3, it expressly recognized concerns about the effect on prices of the IP system. You know, exactly the issues we've been discussing this morning. And there it is in a unanimously adopted WTO declaration. I like to say that paragraph 3 of the Doha Declaration is the most succinct, brief textbook on patent policy and competition policy in 2 sentences. Yes, innovation is fine, but what about the effect on prices? And from that point of view, it has a direct lineage, for those of us who work in the common law tradition, direct lineage to the 1623 Statute on Monopolies, which of course is ultimately a competition policy law and not purely a patent law. It sets patent law even then within the framework of the repression of burdensome monopolies. So from the point of view of the IP system and the application of TRIPS flexibilities, I think it's important to bear in mind, even for the application of TRIPS flexibilities, that they do not guarantee outcomes in themselves. This is not to divert attention from the necessity for action in certain circumstances, but also to recall that they need to be applied in a broader context in cooperation with competition authorities and health authorities. Effective, prompt health regulation and approvals is an important aspect of getting competition happening in the marketplace. Coordination across authorities will be important, even if we're looking just at the application of TRIPS flexibilities. Equally, looking at my broader responsibilities professionally, the broader trade and procurement policies are also very important factors in ensuring there's a pro-competitive approach. After all, after dealing with the initial shock of the pandemic, there is, I think other speakers have stressed this, the need for a pro-competitive approach to diversifying and strengthening access options so that the beneficial effect of competition in the supply of urgently needed materials is brought to bear. I'd like to mention 3 specific items, materials that we've been working on, and it's going to culminate in the publication of edited volume in a couple of months. One is a working paper put together by colleagues that has reviewed the evolution over the last 20 years or so of competition and IP policy, initially in the, if you like, the established jurisdictions, but also emerging jurisdictions and in the BRICS economies. This study looked at the approach taken, the normative approach, the policy approach taken in these jurisdictions to issues such as licensing practices, including refusals to license, anti-competitive patent settlements, standard essential patents, patent assertion entities, and more broadly, the role of competition authorities in advocacy. And this is a very interesting piece of work. I can celebrate it because it's not my own work, it's that of colleagues. And it's an important reminder of the evolution that has taken place. As Professor Correa has rightly pointed out, there was resistance 20 plus years ago to the development of norms or negotiations on competition policy in the WTO. And frankly, between us, I would imagine that absolutely remains the case. And I would stress we're not aware of any push to anything approaching normative development. To the contrary, I think the emphasis, and this has come out in the discussion this morning, the emphasis is on greater mutual learning and greater understanding of the approaches taken in a diverse environment. Diverse approaches are taken, but that also implies that there are really important lessons to learn from that diversity. And this is what this paper points out. There has been, if you like, a de facto process of cross-jurisdictional learning processes and a partial degree of some policy convergence without moving into a lockstep, one-size-fits-all approach. And from that point of view, it points out the benefit of greater dialogue on issues such as refusals to license, but also that important issue that Professor Correa has mentioned, the idea that authorities have applied differing weights within the same jurisdiction, but also across jurisdiction, different weights to different policy considerations, whether it's about industrial policy or consumer welfare or broader public policy objectives. And I think the diverse experience, the fact that many developing countries now, the majority of developing countries now have competition authorities, competition rules of some sort, that's an extremely important foundation for learning from. As a curious historical note, the early work, I think Pradeep mentioned the Havana Charter. Indeed, the League of Nations in the 1920s was working on these issues. And at that time, it was interesting that there was a discussion about the positive benefits of cartels. So from an industrial policy point of view. So from that point of view, it's a reminder that the policy framework of competition policy does evolve over time. I was going to mention also a working paper on TRIPS and competition policy that is also at the point of being published. I'll skip over that simply to stress that three key points. Firstly, that it's not an accident that competition policy considerations are embedded in the TRIPS agreement. It's not an afterthought or a secondary consideration. I would argue that they are built into the TRIPS agreement, and so from that point of view, it does provide something, a contribution to the normative framework for this conversation. But it's curious, the second point, that these that we haven't had a really thorough discussion certainly in the WTO about the members' experience in applying these. In fact, South Africa, and we've had a magisterial presentation this morning, South Africa has actually introduced this item and discussed it in the TRIPS Council recently, and so there's a beginning of this conversation. But it is an integral part of the agreement, and it is perhaps surprising, given the significance of this dimension, that it hasn't been fully developed, including the mandatory requirement under Article 40 for cross-divisional, cross-jurisdictional cooperation. It's an obligation to assist with competition policy matters when it comes to restrictive licensing arrangements. So there is clearly potential there. But my third point that comes from this paper is that indeed we are seeing that interest from the full spectrum of our members. We've seen that, I've mentioned it in the TRIPS Council, but it's in a way more interesting in the trade policy reviews in the WTO. There's been engagement on the IP and competition dimension, as well as competition policy more broadly, which certainly indicates that members across the board have a strong interest in at least a dialogue and a sharing of information and a mutual learning process in this area. And so whatever, I'm not advocating any particular approach, but whatever framework, whatever international foundation can be established for an enhanced conversation, not an abstract one, but a very practical one, focused on mutual learning and sharing of material, that is clearly urgently needed. And this is also to celebrate the role of UNCTAD, CUTS, as well as WIPO in this area, who have been active. I'd conclude by just mentioning specifically on public health. A couple of months ago, we issued an updated version of the WHO, WIPO, WHO trilateral study. This highlights the important role of competition policy, both in terms of innovation in the public health area or the medical technology area, but also access. And this audience knows this very well, but I would refer you to this as an overview of the important role of the competition policy considerations there. And finally, there is a specific focus on COVID in that trilateral study, which notes a number of the actions taken by competition authorities across the globe, investigations relating to COVID-19, advocacy work, looking into issues such as price hikes for health products and diagnostic information, as we mentioned, for example, the investigation in the Netherlands into Roche's dominant position regarding COVID-19 test equipment. Just to note that these resources are there. We hope these would be useful alongside the very excellent material that we've heard about this morning. So that's it for me. I would be delighted to continue the conversation right through the day, but also if anyone has an interest to engage and to share further background material. But thank you once again for the honor and the privilege to join you today.
Thank you very much, Anthony. Thank you. And thank you very much for your kind words for GUTS and its work. Can you hear me?
Yes.
Okay. And then also a key point is that you were making is this, the diversity of experience and the need to share that openly and have that informed, well-informed, serious discussion, including in the WTO. So thank you very much, and for also sharing a lot of work and thoughts, and those links, some of those I can see you have provided in the chat function, and the colleagues can access these very interesting documents. I am aware that we have reached actually beyond the limit of the time, but I hope it is okay for everyone if we can continue for a few more minutes. I saw that there were several questions posted on the chat function. These were directed to, some of them directed to specific panelists, to Carlos Correa, to Alexei, and to Hardin. And then, of course, there are a couple of more general questions as well. Carlos, Hardin, and Alexei, are you able to see those questions on the chat function? I can see that Alexei has already tried to respond. So if that is okay, I would propose that Alexei, Hardin, and Dr. Correa take those specific questions in that order. Then, of course, I will also request after that Teresa and Tony for any final observations in 1 minute each, and then Pradeep will thank you all formally. So is that okay? Alexei, would you like to go first?
It's up to you. I can do it quickly. Uday was raising a point, saying like there is a trend to become innovation hubs for developing countries as well. And is there any kind of conflict in promoting access to medicine and promoting innovation at the same time? So my response would be, to a certain extent, we overestimating the importance of IP rights to promote innovation. And this discussion actually, when we accept it as a dogma to a certain extent, that this is the only institutional framework in which innovation can develop. But actually the discussion which happened back in 50s and 60s was not that simple. And there were like Nobel Prize laureates like Dempsey or Arrow, economists who were promoting different views on this. And Arrow was more like for open market with more intense competition and more open access to resources like data, like innovation, all sort of innovation, like knowledge, information. And and we had different examples, actually. Soviet Union, for instance, which did not protect intellectual property, was innovation hub and was important innovation player on the global scale. Actually, competition during the Cold War of two systems, and Soviet system of promoting innovation through, not proprietary, non-market to a certain extent mechanisms, also relying on competition to a large extent. Actually, socialist competition, such a term which was actively used in the context of Soviet innovative, enterprise, was quite effective because they were encouraging competition driven by all sorts of rewards, recognition, not only by market profits. And the price system based on some sort of different incentives, including, some sort of public recognition incentives, it can work. So we can't say that if you want to build innovative economy, innovation hubs, you have to protect intellectual property to its maximum. It's actually to a large extent vice versa. In Russia, when we introduced intellectual property protection according to the TRIPS even earlier than we were accepted to WTO, we had a huge decline in innovative activity. So intellectual property protection killed innovation in Russian context. In 20 years, we lost basically all innovative potential we had before. So we have different type of examples and different type of institutional structures which can encourage innovative development. So we should not, stuck to the one, model of thinking. And that's very important for developing countries to consider different modalities and different options. Have this, comparison study, made before you jump in with some sort of policy solution.
Thank you very much, Alexei. And it was great that you had also provided this answer in the chat also briefly, but then you explained it a bit more. Great, thank you. I will now request Hardin to respond to the question addressed to him, and then Carlos Correa. Hope they can see the questions on the chat function. And then after that, Tony and Teresa. And then, my apology, I did not mention, then I will also request Dr. Mayaram for any final words from his side. And please try to be brief. We over time. So Hardin, you have the mic.
Oh, thank you very much. The question to me is, what has been the impact of the extensive set of regulations implemented by South Africa to respond to COVID-19 in the healthcare sector? As you know, South Africa, we put out a number of exemptions in the healthcare sector, but also there were price gouging regulations to contain excessive pricing in the market broadly. So what we have seen is that for health essentials, there were some price increases, but we were able to contain those through active enforcement. From these exemptions, we have seen, and this have allowed private and private sector hospitals to collaborate, share beds. They've been able to share medicines, and we have seen a lot of stability in the market. And the exemptions actually, in essence, allowed for collaboration amongst all stakeholders that were involved. Of course, we can only assess the full impact of this over time, as we are still in this pandemic, as you know. But there's just one, if we allow me 30 seconds, what Dr. Correa said about drugs being approved in other jurisdictions. Retailing at $1,000, information pointing to costs to that drug costing $1 or $2. These are the points that Alexei is raising about innovation. What are we rewarding with these protections? So if you have cases like that, and countries continue to export high prices to developing countries who don't have the wherewithal to produce a lot of these drugs, we are going to have a global catastrophe, as I repeat. So I think this is a signal, and it is something that maybe it requires sort of fresh thinking, and this is what Alex is saying, and we look forward, I think, to this paper from the WTO, on competition policy, because this is where I think this discussion will start, and we can be able to know what exactly are we rewarding, because from the competition authority's point of view, we are seeing a lot of exploitation in space. Thank you very much.
Thank you very much, Hardin. Thank you. Now I request Professor Correa.
Well, thank you, Rashid. I could not identify the specific question addressed to me. In any case, I would like
to let me try to
yes,
read it. If I can scroll back quickly, or maybe better still, Uday, if you are there, would you like to say in few words your question to Carlos Correa that you had posted here? Okay, so let me read that question. Uday had asked, how have companies been using their IPs for big profits during this pandemic?
Okay.
How have access and affordability of treatments, drugs been impacted?
Mhm. Well, the question has different aspects or dimensions. As we know, in terms of treatment, many companies try to show that existing products were also useful for COVID-19. This is what we call generally a second medical use of an existing product. In some countries, this would allow for getting a new patent. So some countries allow the grant of what is called a patent on second medical use. So if this were the case, for instance, with Remdesivir or other products, this would mean that despite the fact that the molecule may be an old one, and despite the fact that molecule had been used for another disease, then if it is actually found that this molecule is useful in some way or another for COVID-19, then another patent can be applied for and in some countries obtained. If this is then the situation, the legal monopolies that the patents confer will be used most likely in order to get a high price, not a price based on the marginal cost of production, but a price based on what kind of benefits the company can do. So if you allow me, Rashid, just 1 minute regarding the relation between innovation and intellectual property. In fact,
Yeah,
there is,
please go ahead. Please go ahead.
yeah, no conclusive evidence about this. I really like very much the comments by Alexei. In the context of COVID-19 in particular, it is quite evident that if intellectual property rights are aimed at addressing market failure, and this is one of the most conventional theories about intellectual property rights. In this case, there is not such market failure. In the first place, because there is a huge demand, 7.9 billion people waiting for a vaccine or a treatment. And secondly, because the companies, in particular in the area of vaccine, have received billions of dollars of subsidies. So in the context of COVID-19, there is no justification whatever in order to claim or enforce intellectual property rights on the basis that there is a need to recover research and development or the traditional theory behind intellectual property.
Thank you very much. Thank you, Professor Korea. Now I would request Anthony for any final comments or observation on any of the questions in 2 minutes, followed by Teresa.
Just very briefly then, I thank you for the opportunity. I would firstly say that I think the discussion today has brought home to me something I've often felt, that there's no fundamental distinction between the broader policy debate and the understanding about the broader policy dimension and the very specific practical demands of the day. And certainly, as the discussion has brought home, COVID must force a really thorough rethink of how we see the range of measures that we've been discussing, and I think that reinforces both the need for enhanced international dialogue, and I'm certainly not advocating for the WTO as such. That's a matter for others to decide, absolutely. But the dialogue is clearly necessary and at a very practical level. Capacity building is extremely important right now. And I think it's important to bear in mind that the real challenges confronting actual people working back in capital, in the competition authority, in the health ministry, in the IP office, and understand the challenges they are facing. And I think set the one normative element, I'd say, would be to promote a cross-disciplinary, cross ministry dialogue, so that a coherent approach can be taken. That's certainly what we hope to do at a practical level, at a capacity building level. But whether that can be developed further is in the hands, of course, of our member governments. But I think the discussion this morning really has brought home the need for that kind of work, not only as an ideal thing, an aspirational thing, but as a urgent practical necessity. Thank you. And thank you for being
Thank
a
you very
really
much.
important conduit for this kind of conversation. I mean, really essential. Thank you.
Yeah. Thank you so much, Tony. And now Teresa, and then after that, Dr. Arvind. Teresa?
Thank you very much. Well, there was a comment in the chat regarding UNCTAD. Sorry, may I proceed? Yes. Okay.
No, I think there was a mic unmuted somewhere.
Okay,
So, yeah, please go ahead.
No problem. So there was a reference to UNCTAD in the chat, and I just wanted to clarify that UNCTAD does policy advice, does technical cooperation, promotes consensus building, but it is not for us to allow, between brackets, what companies should do or not. When we mentioned that we had shared a number of concrete measures adopted by competition authorities in response to markets' reactions during the first weeks of the pandemic outbreak. We noticed that how important that would be for competition authorities, especially those less experienced ones, to exceptionally authorize, for instance, cooperation between competitors, so horizontal agreements, if these were extremely necessary to provide for the supply of essential goods and services, and I referred the masks, the hand sanitizers, etc. So this was something that, of course, is always in most competition legislations a possibility, an exceptional one, over a temporary period of time that needs to be completely monitored and followed up by the competition authority itself. So exceptional circumstances justify exceptional measures, but no competition authority would authorize an exceptionally cooperation agreement between competitors without ensuring a number of caveats are fully met. And so when we suggested that this was an interesting policy measure to be explored, that was the rationale of this. Now, on the comments, again, I thought the discussion was extremely interesting. I should say that just, well, I absolutely agree with the interest and the opportunity of exploring other ways of promoting innovation, not based on the traditional approach to IP rights, as Alexei mentioned. I would suggest, because of what Carlos Correa mentioned, that, of course, through these economic recovery packages, concretely to support finding a vaccine to COVID-19, there is a very good opportunity for competition authorities to make their expertise heard and considered in drafting some sort of conditions to these companies, namely to bring the vaccines either to at no cost to all citizens, or other kinds of conditions that not only allow for pro competition, but also serve the public interest everywhere. But to conclude, I would say that I absolutely agree with what Tony mentioned. Of course, you could imagine from an international organization within the UN system. I think there is a huge role for competition authorities and for competition law and policy to improve access, affordability, quality of healthcare products and services, but this cannot be done, of course, exclusively by competition authorities. This entails very important policy options that member states are normally fully justified to make. This has international trade repercussions, intellectual property, health, global health issues. So this should be discussed at the international level between the number of organizations that are already interacting, of course, WTO, WIPO, WHO. But I also agree with Tony that there is a discussion that needs to be further developed at national level, as most countries will have some sort of, will have health ministries, but also in several cases, health regulators. So regulators for medicine and medical devices, regulators of health services, and there is a dialogue and a cooperation that needs to be expanded in order to well, to take into consideration different aspects and to strike the best possible balance, of course, from the point of view of consumers, of citizens, but also of markets. Again, thank you very much to CUTS for this opportunity.
Thank you very much. That is a pleasure to have you with us as always. Dr. Arvind Mayaram, Chairman, CUTS Institute on Regulation and Competition, who are the co-organizers of this webinar, and he had presented the toolkit prepared by CUTS. Floor is over to you for any final remarks before I give the floor to Pradeep for formal thanks. Sorry, I think we are way beyond time, and I have been also seeing some things in terms of internet connectivity. So let me proceed by saying a few words. And Pradeep, are you there? Then I will request you to kindly thank. But first, let me just say a couple of words that a very rich discussion. And my 3 takeaways from that in an oversimplification, that the issue of competition policy and access to healthcare is critical, important, evolving, complex, multi-layered, even before COVID-19 hit us. And in that, several aspects of that, from intellectual property, price regulation, patents, then also the issue of innovation. Then the COVID-19, of course, that brought into sharper focus some of those issues, also led to certain challenges which may require different responses by competition authorities, which may again need to be differentiated based on the immediate term needs as well as the long-term focus. So quite a challenging job for competition authorities, and that's where the third. So in that, the goal should be to continue working towards achieving the SDG, universal access to healthcare, by 2030. And in that respect, the competition authorities need to work in collaboration with other stakeholders at the national level. But also a point mentioned a number of times, either directly or indirectly, is the need for international collaboration, from sharing of experiences, diversity of approaches, and informed, balanced dialogue, so that the national and the international levels can move in harmony with each other while utilizing the policy flexibilities at each level. In that, the need for capacity building of particularly developing countries and LDCs will be critical, so that they can keep pace, they can learn, they can ensure that they are able to have the access to the competition policy tools and employ them towards the achievement of the SDG. So this is a very, 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 very brief, oversimplified my takeaways from here, and we look forward to that collaboration in the coming days and months. And now with that, I will request our Secretary General, Pradeep S. Mehta, to say a few words, formally thank all the panelists, and conclude. Pradeep.
Thank you, Rashid. I think you have summarized it very well. Except that what I could see from some of the discussions, one is that it's an era where trade protectionism is rising, and that is where there is a problem also of supplies of medical equipment, etc., which we have seen happening, and that is an area which we need to also address in terms of international cooperation. Multilateralism has been in decline for several reasons. We hope with the new US administration, multilateralism will get a new push, as Joe Biden has promised. And that is very important for us to understand, Shashi, when you said international cooperation. Now, the instruments for international cooperation themselves are very weak. The US has already withdrawn from the WTO. US, I beg your pardon, the Trump administration, as people wanted to clarify. The second important point which I'd like to make, Rashid, is the point which Alexei made and Carlos also spoke a little. We need to understand as to how much of innovation has TRIPS promoted or not promoted. But that is the main argument which has been made by the pro-TRIPS lobby. If you remember, even during the Uruguay round, TRIPS was opposed by even very sane economists, that this is a restrictive trade agreement. And how can you have a restrictive trade agreement in a trade liberalization agenda, for example? We have to revisit that particular debate in order to ensure that everything else falls into place properly. Otherwise, as it is, this also reflects in a way from the kind of pangs of deglobalization as we've been seeing throughout the world. And why WTO itself is in a kind of a limbo, and how soon it can be spread, as I said, in the context of the broader multilateralism agenda as well. Finally, let me thank both Ujjwal Kumar from CUTS and Garima Sodi from CERC for having prepared this toolkit very painstakingly for some time. And if there are any comments on the toolkit, if they're welcome to say, and I hope that it is comprehensive enough to be able to spread the message around. But Alexei, you and I need to work upon that fundamental issue about whether innovation has been promoted or not promoted by TRIPS. Thank you. Thank you very much. Thanks to all the panelists. It has been a very enriching debate. And as I said, there is a live recording. And any of you and anybody in the audience or not in the audience can also visualize, can also see this. One little point I wanted to mention to you finally, our sister organization in Pakistan, the Sustainable Development Policy Institute, is also organizing a session on this on 16th of December. And some of you are speaking there as well, in the morning at about 9:45 a.m. Pakistan time, which is roughly about 10:15 a.m. Indian time and so on. So all of you are welcome to that particular thing. We'll of course share a summary of the discussions here at that particular discussion and take forward the discussions. Thank you very much, Rashid. And thanks to all very much. Bye-bye.
Thank you very much. Thank you very much, Pradeep. Thank you very much, Teresa, Hardin, Carlos, Alexei, Anthony, and Dr. Arvind. Thank you very much, Garima and Ujjwal. And thank you very much, Julian Grolier. We had a wonderful discussion. We went way over time, but that each minute of that was worth it. So thank you for the participants, and thank you very much, Pradeep. With that, goodbye from Geneva.
Goodbye. Thank you.